started here just as everyone continues to filter in. But welcome. My name is Doug Betancourt. I'm the president of the Federalist Society here at Suffolk, and we're very excited to put this event on today with two great speakers here today. Without further ado, let me introduce the speakers that we have for you here today. First is Professor Josh Blackman. He's a national thought leader on constitutional law in the United States Supreme Court. Professor Blackman's work was quoted during 2 presidential impeachment trials. He is testified before Congress and advises federal and state lawmakers. He regularly appears on TV, including NBC, CBS, ABC, Fox, and the BBC, and is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and leading national publications. Since 2012, Professor Blackman has served as professor at the South Texas College of Law, Houston. Professor Blackman is also an adjunct scholar at the Cato Institute. He has authored 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon, and he has written more than 5 dozen law review articles that have been cited nearly 1,000 times. Professor Blackman was selected by Forbes magazine for the 30 under 30 in law and policy, and he's the president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league. So without further ado, it's Professor Blackman.
Thank you so much. It's a pleasure to be here. I love evening students, by the way. So I teach at law school at the evening division, and I find that evening students bring a different perspective to life. So I'm glad to see you all here at night at 6 o'clock to hear us talk about the Supreme Court. At the Supreme Court. And it signals the justices are going in a different direction. So just a little bit of history. Between 1994 and 2005, the composition of the Supreme Court did not change. Justice Breyer remained the junior justice. So a fun fact, if you're the youngest member of the court, the newest member, you have a job. You have the cafeteria committee, right, to keep you humble. So Justice Kagan's big accomplishment was a frozen yogurt machine. So if you ever go to the Supreme Court and you get frozen yogurt, you thank Justice Kagan. But from 94 through 2005, the composition of the court stayed the same. But over the last 17 years, we have had 8 new justices. In 2005, we got Chief Justice Roberts and Justice Alito. In 2009, we got Justice Sotomayor. 2010, we got Justice Kagan. Then the court was fixed for a bit. Justice Scalia passed in 2016. After the election, we didn't get Merrick Garland. We got Justice Gorsuch. About a year and a half later, we got Justice Kavanaugh to replace Justice Kennedy, the big swing vote. Then Justice Ginsburg passed, and we have Justice Amy Coney Barrett, who replaced Justice Ginsburg. I'm almost out of fingers. And then, just about 3 months ago, we got Justice Ketanji Brown Jackson, who replaced Justice Breyer. So we have 8 new justices in the span of about 17 years, which is a stunning turnaround after virtually no change in more than a decade. And the biggest changes, of course, reflect the center of the court. For the longest time, it was Justice O'Connor, Justice Kennedy, moderate Republican appointees who would sometimes go to the left and they sometimes go to the right, depending on what they have for breakfast on a given day. But now the center of the court is actually Justice Kavanaugh, or Chief Justice Roberts, who is a far more reliable conservative member of the court. And we see the new conservative court flexing their muscle in at least 3, maybe 4 primary areas. And that's what I want to talk about last year. So fairly boring stuff we'll talk about. Abortion, guns, and religion, right? Nothing that big. But we got it all last year in rapid succession. So the first case I want to talk about is Dobbs versus Jackson Women's Health Organization. Mississippi enacted a law that prohibited abortion at 15 weeks. All right, now, how many of you took common law already? Oh, good. Okay, almost every hand. Good job. Right? I never know who I'm talking to. All right, so you probably learned about Roe v. Wade and Planned Parenthood versus Casey. These precedents say that you cannot prohibit abortion prior to the point of viability. 15 weeks is way before viability. It's, depending if you ask, 23 weeks, 25 weeks, something to the 20s, but not 15. Why did Mississippi enact this law? The express purpose of this law was to challenge the Roe v. Wade precedent. There was no joking about it. This is why they did it. And they explicitly said, we have now a more conservative court, and we want to see if this new law will survive. So the case goes to Supreme Court. And there's a couple questions to think about, right? First off, was Roe correct as an original matter? And even in Casey, the court said, well, maybe Roe was right, maybe it was wrong, but there are other reasons to keep the abortion decision. Right, why? Well, for one, people have come of age relying on the Roe decision. It's something they've known they can have in their life if they need to have it. Another thing to think about is stare decisis, the idea that you stand by the court's precedent. Even if Roe was wrong in the first instance, there are reasons to stand by it in any event. There's another concept you may have heard of called legitimacy, the idea that the court has to be viewed in the public sphere as a non-political institution. And when the court rapidly changes its opinions after new judges are appointed of a different political party, that signals to the public this is not a legal court. It might signal to the public that this is a politicized court. Now, these were all the rationales that the Casey court adopted of why they stood by Roe. Those arguments didn't work this time. In fact, the majority opinion by Justice Alito said expressly, it is not our job to consider how the public will perceive our opinions. That's not our job. In fact, he said, it's improper for judges to base their decisions on political and popular thought. What the court said is, we will let the political process work its way through. We will defer to the political branches. Abortion is no longer a matter for the courts to decide. The dissenters, by Justices Kagan, Sotomayor, and Breyer, had the exact opposite position. They worried what would happen if the court was perceived in this political fashion, that whenever there's new members in the court who are more conservative, they can sort of jettison these old precedents. So what have we actually seen since the Roe decision? For a while, abortion was a red-hot political issue. But I think at some point, though, politics catches up with reality. For years, politicians could pass laws that were never going to be enforced, and they'd suffer no political consequences. I think what we're seeing now is that politicians who perhaps support very stringent abortion laws will have to answer to the voters. And that's not a bad thing. I think if there's one lesson that this court is teaching people, is that if you're on the left of center, you cannot rely on the court for anything. You cannot rely on the court to pursue the policies you think are important. Rather, it's a democratic process. For generations, law students were taught that the court was this font, this source of progressive justice. That ship has sailed. And I think what the current court's signaling is if you want something, you have to vote for it. So this is one case in which the court signaled that we're not going to sort of rely on these, court-created rights like abortion. The next case I want to talk about is a different right, which involves guns. In 2008, the Supreme Court decided a case called District of Columbia versus Heller. Heller recognized the Second Amendment is not linked or not bound up with malicious service, as perhaps some people contended, but instead was based on individual right to keep and bear arms for self-defense in the home. All right? But self-defense in the home doesn't go beyond your doorstep. What about the follow-up question? Is there a right to bear arms outside the home? For nearly a decade, the Supreme Court avoided this question, and most of the lower courts held that even if the Second Amendment extends outside the home, the government can require good cause or proper justification to carry. That is, you must have some special reason why you need a gun. Self-defense is not enough. Finally, last year, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin, B-R-U-E-N. And what Bruin held is that the Second Amendment guarantees the right to carry firearms. And it must be given people based on objective criteria, not subjective, objective. Remember from contracts and torts, subjective, objective, right? The government can make you pass a background check. They can make you take a proficiency exam. They make you fill out some paperwork. But what they can't do is ask you to show, why do you need a gun? Why do you really need this right? Is this really important to you? They cannot do that. So as a result, the laws in New York, New Jersey, Massachusetts, and about 7 or 8 other states were rendered unconstitutional. So the rule now, at least in theory, is that if a person passes all the requisite background checks and various other objective criteria, they should have a handgun license. New York is still trying to sort of futz with it. New York is we will not check if you have good cause, but we will ask, do you have good moral character to have a gun? Good moral character. So you're all lawyers, the lawyers to be. Character and fitness, right? This is a very subjective standard. In fact, New York asked, I'm not joking you, they actually asked firearm applicants to list all their social media handles so that the government can go through your tweets and your posts to make sure you don't have anything negative in your record. I don't think that's going to stand. I think New York is overreaching just a bit. At present, 43 states already had what's called a shall issue regime, where if you apply for a gun license, you shall be issued a license. I think all the other states will join those ranks soon enough. Now let's talk about religion for a bit. And there are actually 2 related cases, one from Maine, one from Washington, so on the very far ends of our coasts. Maine is a very rural state. Anyone from Maine here? No one's from Maine anyway. Maine's a very rural state. I'm going there tomorrow. I'll talk about it later. Maine's a very rural state. And in many areas, there are actually no public schools. And so the government has a policy. If you live in one of these very isolated areas and there's no public school, the government will give you money to go to a private school. Unless it's a religious school. Why does Maine have this policy? Well, they were afraid that if they provide money to a religious school, it might violate the Constitution's Establishment Clause. For generations, the court said that there's a separation between church and state, and that governments must avoid entangling themselves with religion. All right. So a number of parents in Maine sued, saying this is unconstitutional. They're violating our free exercise rights to worship by denying us the ability to fund these schools. The Supreme Court ruled in favor of the parents in a case called Carson versus Macon. What the court said is, you cannot discriminate on the basis of religious status or use. That is, even if the money is going to be used for some religious instruction, buying Bibles, right, paying for religious teachers, whatever you want, that is still permissible. Why is this ruling significant? 30 years ago, the Supreme Court would have probably held that it was unconstitutional to provide funding to these religious schools. But the current court is taking the exact opposite position. The failure to fund these schools is itself unconstitutional. So we've really gone full circle on separation of church and state issues. The current court is locked solid on allowing religious exercise in these contexts. All right. The second religious case I want to talk about concerns prayer. In Washington State, you had a high school football coach, actually an assistant coach. His name was Coach Kennedy. And after every game, he would take a knee at the 50-yard line and pray quietly to himself. Now, people would sometimes come around him, stand next to him, and pray with him. The school district said, hey, coach, we're paying you to coach the team, not paying you to pray. Stop it. So the coach said, okay, I'm going to sue you. And he took them to court. And the argument was that the coach had a free speech right to pray after the game. It wasn't during the game, it was after the game. But the school said, wait a minute, if we allow this guy to pray, we're going to violate the Establishment Clause, sensing a pattern here, right? That, actually, I got another religious case from Boston. I'll give you this one in a minute. They're violating the Establishment Clause, right? We don't want students to feel coerced, right? Imagine you're a player in the team, and then you see your coach praying. And you might feel pressure, well, maybe if I pray with him, I'll get more playing time, right? And so the school district said, no, we can't allow this guy to do this. Goes to the Supreme Court, Coach Kennedy prevails. And the Supreme Court overruled an entire line of cases, was known as the Lemon Test, the Lemon Doctrine, which says you can't have this entanglement between church and state. What the court says is you have a free speech right to speak. You can talk whatever you want. And you can pray after the game. Now, what about the coercion, right? Doesn't this coerce students? The court said no. unless there's evidence of direct coercion, that is, the coach is saying either you pray or you don't play, right? Pray to play, as it were. Unless there's evidence of pray to play, there's no coercion. Here the court, I think, has put in tension decades of doctrine which said even indirect coercion might be sufficient to violate the Establishment Clause. All right, I forgot I'm in Boston. One more case that's close to home. Shurtleff versus City of Boston. Where's City Hall? Is it close by?
Very close by, yes.
Where's just point? Where am I?
I don't know if I would be pointing in the right direction, but
I'm
very
sorry.
close by,
When we talk
yes.
about the Harvard case, I think it's over there somewhere, right? So City Hall is somewhere nearby, and there's a flagpole. Maybe you never noticed it. I don't know. And the city has a policy that says if you bring a flag to the city and you request a permit, we will let you raise your flag up for whatever purpose you want. And this went on for years. So if, let's say, you had a sports team, or let's say you had a civic organization, or the flag of a foreign country, or maybe in Suffolk University, they probably had a flag up there at one point. So every flag got approved until, you know where this is going, right? A group had a flag with a cross on it. There were other icons, but there's a cross on the flag. And it was for a Christian group. And the Boston city government said, "Ooh, no, we can't do that. We can't raise a cross flag because this might violate the, where I'm going with this, right? Establishment Clause." The city was worried about the separation of church and state. So you know where this is going, right? The Supreme Court said, no. Raising the cross flag would not violate the Establishment Clause. And oh, by the way, you just discriminated against the group because of their viewpoint, right? This is a viewpoint discrimination. Every other group was allowed to raise their flag except for the Christians. So the court ruled actually 9-0. This was not even a 5-4 case, 9-0. Justice Breyer wrote the majority opinion, holding that the city of Boston violated the First Amendment. By the way, the First Circuit ruled for this easily, piece of cake, right? 9-0 reverse. So these religion cases teach, I think, a very coherent lesson, if you want to call it coherent, is that there's no flexibility, right? If you're worried about violating the Establishment Clause, just don't worry about it. You should put the thumb on the side of the scale in favor of free speech and free exercise clauses, right? In all three cases involving the funding in Maine, the flag in Boston, and the coach praying in Washington, it was the same thing. You cannot violate the freedom of speech in order to avoid an Establishment Clause problem, because there is no problem. There is no Establishment Clause problem. All right, so these are the big issues from last year. We got abortion, we have guns, and we have religion. The term coming up might prove even more significant with the case that my good friend Professor Reyes will be talking about in a moment.
Great, thanks so much, Professor Blackman, both for being here today and also for your remarks. Did you want to say something, Doug?
I was going to introduce you, yeah.
Well,
Oh, I'm
most
sorry.
people know
I'm
me.
sorry.
Most people here know me, so if you're welcome to, but I'll defer to you.
I'd like to introduce our other speaker today as Professor Reyes, Suffolk's own professor.
Suffolk's own.
So Professor Reyes joined the Suffolk Law faculty after serving as a Clemenco Fellow and lecturer at the on law at Harvard. Prior to entering academia, Professor Reyes practiced trial and appellate litigation at Goodwin Procter LLP and served as an assistant attorney general for the Commonwealth of Massachusetts. He received his JD from Harvard Law School and his AB from Harvard College. Professor Reyes' scholarship focused on U.S. constitutional law, comparative constitutional law, and law and religion. Some of his recent work has been published by the University of Pennsylvania Law Review, the Michigan Law Review, the Virginia Journal of International Law Digest, and the William and Mary Bill of Rights Journal. He teaches courses in constitutional law, equal protection and due process, and constitutional criminal procedure. And Professor Reyes enjoys British history and culture, exploring the city of Boston and traveling with his family. And he's an enthusiastic supporter of the Boston Red Sox and the Tottenham Hotspur FC. So, welcome, Professor Reyes.
Great, thank you very much. So, you've got my dating profile. You can swipe one direction or the other. If you like exploring the city of Boston and following sports with me, right? Again, thanks to Professor Blackman for being here and for hitting some of the highlights of last term. I'll just offer a little bit of commentary on some of those cases from last term, then transition to a discussion of what's coming down the pipe this term. Listening to both listening to what Professor Blackman said, reflecting on my own and what the court's done in the past year or two, I'm really reminded of a line from one of Justice Scalia's opinions a number of years ago, where he accused the majority of prowling hungrily through the statute books, looking for a statutory provision that suited their purposes. Now you see the court's current conservative majority prowling hungrily, right, through the U.S. reports, looking for opinions that they would like to revisit. And this seems to be almost a militant appetite, right, for let's sweep the jurisprudential board clear of all of the constitutional errors that our predecessors may have made. And it's a striking willingness to revisit and either overturn or at least modify very long-standing precedent. So Roe, of course, 50 years was the law of the land. That's now no longer the law of the land. In the religion context, Employment Division versus Smith, dealing with rights of religious objectors to exemptions from generally applicable laws, that's been the law of land for over 30 years. It's been significantly weakened in the last couple of years with the adoption of the so-called most favored nation approach to religious exemptions. There seem to be at least three, unambiguously at least three, and possibly as many as 5 justices who are now ready to revisit and overturn Smith altogether. The affirmative action cases, at least since the Bakke decision in the 1970s, so 45 years or so, that one, again, likely to be overruled this term. At least that's what I expect. Be interested to hear from Professor Blackman on his expectations. And there may be others. New York Times versus Sullivan, for example, the requirement that public figures seeking to establish defamation show actual malice. Some indications from some of the court's justices that, yeah, that one's ripe for re-examination too, even though that's been around since the 1960s. And one of the many things that's striking about this willingness to revisit and perhaps overturn these precedents, none of those cases that I just identified were written by democratically controlled majorities or Democratic appointees on the Supreme Court. Roe itself, that was a 7-2 decision back in 1973. It's kind of hard to imagine that it was so, relatively speaking, uncontroversial at the time it was decided. 7-2 with many Republican justices joining the majority opinion. Religion context, Employment Division versus Smith, decision written by Justice Scalia, right? The conservative icon, and the conservative view was that you're not entitled to an exemption from generally applicable laws. We rely on majority rule, democratic lawmaking process. Well, at least that's the case for as long as it's just Native Americans who are denied the right to smoke peyote, right, as they'd done for thousands of years before white colonizers came and discovered them. But suddenly, when the output, right, the end product of majoritarian governance starts to produce laws that are inconsistent with some conservative Christian practices. What, we can't discriminate against gays and lesbians? Suddenly now the majority says, yeah, maybe we need to revisit Smith. Maybe this is really problematic, saying that religious exemptions ought to be left to the majoritarian democratic lawmaking process. Affirmative action, again, some of the most recent decisions, Fisher and Grutter, those were written by Justice Kennedy, Justice O'Connor, both of whom appointed by Ronald Reagan. So again, it's not as if the current majority is kind of undoing the work of liberal appointees or Democratic appointees. This is just a hyper-conservative brand of judicial activism where no precedent seems to be safe, at least if it doesn't live up to the expectations of the court as currently composed. And it's also striking at the same time, right, how this appetite for overruling precedent is so selective, right? Some precedents, yes, we have to revisit them. Others, though, no, that's settled law. We're not going to disturb it. And Dobbs provides a nice illustration of that within the opinion itself, right? So Roe versus Wade, a 50-year-old precedent, 50-year-old line of cases saying there is, in fact, a 14th Amendment liberty interest in reproductive autonomy. Court says, yeah, forget about stare decisis. We don't need to be constrained by that because this was wrongly decided, so we're going to revisit and overrule. In the course of so doing, they say, oh, and by the way, there's this argument that denying women the right to terminate a pregnancy, that violates equal protection. Yeah, that's settled law. Doesn't violate equal protection. That gets a single paragraph. We're not going to revisit that because it's settled law, but now we're going to spend page after page after page doing what? Upending settled law, right? So lots of tensions and inconsistencies there that shows that while some rights, yeah, the court says this is to be left to the democratic lawmaking process. If it's abortion, matter for the public to decide. But if it's gun rights, if it's restrictions on who can own a firearm, well, no, we can't leave that to the democratic lawmaking process. We can't let Massachusetts and New York and other states have their own rules that are more restrictive than what you might find in Texas or other jurisdictions. That requires judicial intervention or laws that don't provide an exemption for religious objectors. Well, can't leave that to the political process. We have to intervene in the name of protecting constitutional liberty. So some rights, some constitutional rights, more favored than others under the court's current approach, something that's, I think, been on vivid display in the past couple of terms. Something else that's striking about the court's decisions last term and more recently, methodology, right? So the role of originalism in constitutional interpretation. It just seems to me that it's impossible to take this seriously as a value-neutral methodology. If you look at kind of the selective episodic invocation of history and this kind of search for the Goldilocks zone, cases like Dobbs or Bruin, well, this history, that's too old. This history, that's too new. This history might be in the right time period, but we don't find that history compelling or persuasive, so we'll distinguish that. And then you're left with a small subset of history. Lo and behold, what you're left with favors the outcome that the conservative justices would like to see from the very beginning. It just doesn't even, in my view, doesn't even pass the laugh test. This is clearly not a value-neutral approach, at least as it's being practiced by the justices of the Supreme Court. It's not constraining. It's not value-neutral. It is, as I think Reva Siegel described it, it's living constitutionalism under another name, right? So we're invoking originalism as a narrative to frame value choices, as the Republican Party's commitments to ending abortion, for example, came to the fore in the 1980s. Let's embrace this methodology, this narrative of originalism to mask kind of the partisan influences that are really driving the court's decisions in many of these cases, right? So transitioning then to the current term. One case that I'm particularly interested in, or a pair of cases, the Students for Fair Admissions versus Harvard and North Carolina, posing this challenge to race-conscious affirmative action in college and university admissions. Again, decades-old precedent says, yes, that is indeed consistent with the Constitution. Diversity is a compelling government interest. States are indeed free to embrace race-conscious affirmative action. Very likely to be overturned. Again, I think, but I'd be interested again in hearing your thoughts, by the end of this term. And the strategies that are being employed, to me, very consistent with long-standing approaches by white majorities to divide communities of color from one another, to use race as a wedge issue where there might otherwise be common ground and solidarity. Let's see if we can't split and fracture and promote divisions among racialized groups. So again, cases like Fisher or the Grutter case out of Michigan. You have a white applicant who claims they were discriminated against. That didn't work. Didn't convince the court to strike down affirmative action. So now the strategy is, let's not have a white applicant who was denied admission. Let's find an Asian American applicant, right? So this is also a member of a racialized minority group, and see how they're being discriminated against. Affirmative action isn't just unfair to whites, it's also unfair to Asian Americans. Therefore, we need to strike it down. Color me skeptical, right? If about the underlying motivation. Is this case really about vindicating the rights of Asian Americans, protecting some minority groups? or is it really about limiting the role of race that typically tends to operate in affirmative action to the supposed or perceived detriment of members of the white majority? We'll see how that turns out, but something I'm going to be very interested in watching out for is whether the court honors its ostensible commitment to originalism as a methodology in deciding this case. So if originalism is the way to go when you're talking about abortion, if originalism is the way to go when you're talking about free exercise, if originalism is the way to go when you're talking about rights to gun ownership, is originalism the way to go when you're talking about affirmative action? So you might recall from the slaughterhouse cases reaching the Supreme Court just a few years after the adoption, ratification of the 14th Amendment. The justices say, look, it's all fresh in our memory. We all know what these amendments are all about. It is clear, unambiguous, that these are about protecting and promoting equality for recently emancipated enslaved people. It is about protecting black Americans. And the court says, what was the language in the opinion itself? That they think it would be inconceivable, right? We doubt very much whether any action of the state not directed by way of discrimination against black people as a class or on account of their race will ever be held to come within the purview of the Equal Protection Clause. And yet that provision that was originally intended to be a vehicle for protecting and vindicating the rights of racialized groups is now flipped on its head, right? It's being invoked by members of the white majority to say, no, you cannot legislate in a way that vindicates the rights and equality of interest of racialized groups. So if you think about originalism in terms of original intent, that's a difficult one to deal with. If you think about originalism in terms of original understanding or original public meaning, once again, there are real problems for those who want to challenge race-conscious affirmative action. There's significant evidence, for example, that the same Congress that passed the 14th Amendment also passed race-conscious affirmative action measures that gave preference to black Americans. So it seems to be a lot of historical evidence that's been conspicuously absent, right, from any of the court's previous Equal Protection Clause jurisprudence dealing with that question. Even the most fervent critics of affirmative action, who are also associated with originalism, Justices Scalia, Justice Thomas, have yet to engage with this body of historical evidence in any of the affirmative action precedents. Instead, you get kind of, moralizing objections. Justice Thomas, for example, saying he thinks there's a moral and constitutional equivalence between race-conscious laws that exclude and affirmative action measures that are designed to include. So the very kind of value-oriented discussion that's criticized in other contexts seems to displace the historical analysis when it comes to the Equal Protection Clause. So will the current composition of the court actually confront that evidence? Now, maybe, again, they'll distinguish it. That's another, again, truth about originalism. You can always find some historical evidence to favor your preferred outcome. You see that in Heller, for example, the first Second Amendment case. Justice Stevens says, look, I'm not an originalist, but let's play the originalism game. Let's say, for sake of argument, that originalism is the most appropriate way to decide this case. Look at all this historical evidence that we can point to that shows that the original understanding of the Second Amendment does not support the kind of right to keep and bear arms unconnected to malicious service that the majority is saying that it does. So far, again, the court's originalists have never even engaged in that kind of analysis. So will they do so this term remains to be seen. Again, what does this pattern have to say about the court's legitimacy? It's another point Professor Blackman raised, and there are various ways that you can think about legitimacy. You can think about it kind of from the perspective of constitutional or political theory, right? You could say, well, gee, it's just simply never legitimate for an unelected body of judges to sit with supervisory power, judging on the wisdom of the acts of Congress, other democratically accountable branches of government. Ever since Marbury versus Madison, of course, that argument hasn't really been seriously taken as part of our constitutional tradition. We do have judicial review, though you could question the legitimacy of it as an institution. Or you could say it's legitimate depending upon how it's exercised. Maybe it's legitimate if the outcomes promote equality, democracy, equal dignity, liberty. Not legitimate if it doesn't. And then finally, another definition of legitimacy just focuses on what people think, right? Do members of the public regard the court as a legitimate institution? And here you're seeing clear evidence that the public is saying not so much. Gallup, now survey data can only tell us so much, of course, but Gallup has been surveying the public on this kind of question for the last 50 years, and currently the court's status in the public estimation is at an all-time low. Less than half of the American public expresses any confidence in the Supreme Court as an institution. Justice Alito says, well, we're not supposed to care what people think. Other justices much more concerned with institutional legitimacy. So it'd be interesting to see if that trend continues and what, if any, influence that might have on the future course of judicial decision making. But rather than holding forth in any greater detail, I would much rather be in conversation with all of you and with Professor Blackman. So I will wrap it up there and hear what the rest of you have to say.
All right, thank you. Q&A? Want to do Q&A now?
What was that?
Want to do Q&A now?
Yeah, we have a microphone. If anyone has any questions, just let me know. This is just for the people that are on Zoom, so we can get. Does anyone have any questions for either speaker? Yeah, you want to start? Or I'll start.
Hi, my name's Jackson. I'm a 2L. I just had a quick question about the Coach Kennedy decision. I know that the court came under fire and was criticized for manipulating the facts of that case. I know the appeals court judge, ruled against the coach, and then the Supreme Court reversed that and kind of manipulated the facts, and then did away with the lemon test, or appeared to do away with the lemon test. How, as law students, can we sort of practice in an environment like that does away with long-standing precedent?
Well, the first part about the manipulating the facts, there's actually a dispute over this. I know there was an article, I think it was in the Seattle newspaper, it was an op-ed, saying that he was never fired and that Paul Clement, the lawyer for the school district, lied to the Supreme Court. And then Coach Kennedy had to respond saying that he was basically effectively constructively discharged, which in legal terminology is you were fired because you had no choice but to either comply with the edict or give up the right you're trying to protect. So I'm not sure if there was manipulation of the record. The actual school district never accused the other side of lying. Right? They could have, they didn't, and they didn't challenge that. But the second part of your question is how do you be a law student in an era where laws are changing quickly, where precedent's being abjured? I wasn't alive in the 1960s. We're in review? No. This law school was here in the 60s, wasn't it?
Yes.
If you were the law student in the 1960s, stare decisis didn't matter. Precedents overruled in footnotes. The Supreme Court overruled precedents and footnotes when no party asked it to, right? If you want to know what law school is like in the 60s, that. And yet, a generation came of age saying, that's good, right? This is what courts should emulate. So if you want to summarize what the courts are doing now, it's the anti-Warren court, right? What I see the enterprise now is cleaning up the mode of thinking that began with the Warren court and stretching to the rank with many Republican appointees, Kennedy, O'Connor among them, to sort of change that style of thinking. And I think the only way to accomplish this is, what Alito said is, we don't care. And even if the court takes an institutional hit, however you define that, I think they're content to that so long as they think the law is coming back in the direction they think is proper. So how do you as law students do it? For one, take originalism seriously, right? Even if professors think it doesn't pass the laugh test, judges on the bench do. So if you think it's a joke, write originalist briefs. If you're a public defender, you better damn sure you make arguments in original meaning. If you're a civil rights litigator, talk about the Civil Rights Act of 1866, the Freedmen's Bureau Act, legislation passed by the Reconstruction Congress. I agree that there's a lot of area of the Reconstruction era that that Justice Thomas has really never addressed. I think it'll come up in about 2 weeks or so in the arguments in the Harvard and UNC cases, but that's something to address. But what's the expression? You fight the war with the army you have, not the one you want. Whether you like it or not, this is the courts you have, and you have to deal with it.
Yeah, and I would just add to that that's one of the skills that one tries to develop as a lawyer, right? To how do you deal with doctrinal uncertainty, which is why we practice so many of the things we do in class. What if we change the facts somewhat? What if we see that this line of precedent isn't as stable as we might have thought it was? How do you argue in the face of uncertainty? We're trying to equip you and all of you trying to develop the skills and tools to navigate that. And part of that process is understanding the realities, right, of the instability of constitutional jurisprudence. It does no one any favors to kind of pretend that there is stability if in fact the opposite is true. So it's important to confront and acknowledge that to better equip you to be a more successful advocate. A couple other points to just respond to some of what Professor Blackman said. Again, says that the court cares about originalism, cares about history. So yeah, you ought to care about it, right? Reyes says doesn't pass the laugh test, it's a big joke, but the justices take it seriously. Point I'm making is they take it seriously except when they don't, right? Only when they like the history that's being presented. Sure, we love originalism, or we love to focus on the original public meaning as long as we're dealing with evidence that supports our present 21st century preferred meaning. So yes, by all means, be aware of who your audience is. If you are dealing with a court that looks at, or at least ostensibly appeals to historical evidence, provide it, but do so with eyes wide open, right? And the public needs to go into things with eyes wide open. We need to realize that this is not, in fact, a value-neutral, constraining form of constitutional interpretation. Let's call it out for what it is, right? That's a point I make in class that will be familiar to many of you. You may agree with the substantive outcome in cases like Heller. You might agree with the substantive outcome in a case like Dobbs. You might agree with these conservative opinions substantively, but it's fine to both agree with the opinion substantively and to recognize the methodological flaws, right, in the way that the court is getting there. So I don't think there's any inconsistency in saying, yeah, the court is being highly selective and opportunistic in its use of history. Poor job, right? Methodologically, not convincing, but you still agree with the outcome. So let's just bring that part into the open. Let's not pretend that this isn't a conversation about values and outcomes. Be more transparent, be more authentic, right? So everyone can really have a fair understanding of what the rules of the game really are.
All right, next question.
I don't think I need to. Okay. So I have a question. This is for Professor Reyes. A little bit confused about how could you make an originalist argument for affirmative action. So the founding fathers made clear in the Federalist Papers that virtue and competence should be the most important, if not the sole indicating factor in furthering or selecting those who should govern. So how could you make an originalist argument for an affirmative action when the founding fathers were not even paying attention to skin color back then, only competence and virtue?
Okay, so that is emphatically, manifestly false. I mean, I say that respectfully, but I want to be unambiguously clear. To say that the founding fathers were not looking at skin color is ahistorical in the extreme, right? So you think about those, demigods of democracy that we lionize, the founding fathers, oh, for another, Washington, oh, for another Jefferson, oh, for another Madison. Slaveholder, 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 one and all, right? And slavery, racialized inequality, woven into the warp and woof of American constitutional law from the very beginning. The language may have been euphemistic, but the import unmistakably clear. So I just want to make sure that there's no doubt about the role of race in the constitutional founding. That's one point. Second, Federalist Papers, again, might be interesting historical political advocacy. It's not the Constitution. It's not constitutional law. So if you talk about affirmative action and originalism, most originalists would say that what you look to in terms of how you interpret it is this historical understanding at the time the relevant constitutional language was adopted. So what was the original historical understanding in 1868 when the 14th Amendment was ratified? Well, original understanding there is gee, we just fought a long and bloody civil war primarily to end racialized human slavery. That's an important set of context, right, for understanding the original intent and the original meaning, the original understanding. And the very same Congress that drafted and passed that language, right, says, yes, equal protection clause. No person shall be denied the equal protection of the laws. Same Congress that wrote that language passed laws that engaged in race-conscious affirmative action. So what does this language mean? An originalist would say, look to what people were doing at the time the language was passed, and lo and behold, the same people who wrote the language were in fact engaged in race-conscious affirmative action. So if you embrace originalism as a methodology, there's your argument in favor of upholding affirmative action.
Yeah, I don't quite agree with the question either. But let me try a different response. Respectfully, I feel bad telling students they're wrong, but you handled that, I think. I'm always here. But let me try it a different way. There are arguments that the actions of the Reconstruction Congress are not exactly consistent with what affirmative action is today. So a couple points in response. One, there is an equal protection clause of the 14th Amendment, which limits the states, right? There's no equal protection clause for the 5th Amendment, which binds the federal government. And there's some argument that the members of the founding of the Reconstruction Congress thought that indeed different rules applied. They didn't trust the states. The states had just waged a bloody civil war to maintain slavery as an ideology. So perhaps the rules governing one branch of government were different than the rules governing the other. That's not consistent with present-day jurisprudence, but it's an argument. Another one is if you look at these various pieces of legislation, they weren't exactly race conscious. They referred to the freedmen, who were, of course, ostensibly black. But it was designed to protect a specific race that was oppressed through slavery forever. That may not extend to Hispanics or Native Americans or other groups that perhaps are the benefits of affirmative action today. I'll give just one third point. Even if, in the immediate aftermath of the bloody Civil War, certain race-conscious measures were necessary to bring the freedmen into the fold of society, that argument may not exist 150 years later with a very different civilization. That is, in other words, even though it was an exigency that justified the use of race-conscious measures in the 1860s, that may not justify what Harvard and UNC other schools are doing today. One last point in the Harvard case. Harvard's not a state school, right? It's not UMass, right? It's a private institution, which is subject to Title VI, which is a federal civil rights statute that says you cannot discriminate on the basis of race. So even if Professor Reyes is right in the 14th Amendment, and I think he has some good points, I'll concede them, he might still have to deal with Title VI, which is far more explicit. And if the court holds that Title VI bars the use of race, that affects Harvard, that affects UNC, that affects Suffolk. So really, the general norm is you only reach a constitutional question. You don't reach a constitutional question if there's a narrow statutory argument. I think the court goes for the statute. I think what they just do is they overrule Baki's reading of the Title VI, and they say Title VI and 14th Amendment may be different. We have to decide it, but this violates Title VI. And if they do that, they'll have Bostock and say, we don't care what the framers intended. We care about the words. No race means no race. Good luck, universities. Have at it. And then the Constitution remains the same. That's my prediction for the Harvard case. I don't know how you think they'll decide, but that's how I think they come down.
Yeah, and just to follow up, there is, of course, the companion case UNC, right, which is a state school, so the court will have to reach the...
No, they can do... UNC is bound by the Title VI also.
Yes, of course, it is possible, but likely, in my view, and, predictions aren't worth the paper they're written on, so wait and see what's ultimately written, but with just quick response to the idea, the suggestion that, well, we don't need affirmative action anymore, right? We're 150 years past the Civil War. I'm surprised any of you have had classes with me to hear that I disagree, but rather than going on in any detail or at length, I'll just cite a couple of statistics, okay? So look at the experience in states that have ended race-conscious affirmative action in university admission. So California and Michigan, for example. Those states, as a matter of state constitutional law, cannot engage in race-conscious affirmative action. Black student population at the flagship universities in those schools, 4% in Michigan, about 3.5% in California, right? Vanishingly small percentage in the absence of race-conscious affirmative action. And it reflects also, I think, kind of this fetishization of test scores and grade point average, as if that is somehow the sole or indeed the best definition of merit. That's what it means to deserve to get in. Well, says who? Well, it says the white people who have the higher test scores and higher GPA. They say, well, that's the definition of merit. But colleges and universities shouldn't be required to subscribe to that definition. They can adopt a different view of what it means to deserve to be in my college or my university, what you can contribute, something that they can value, they can say we value, quite apart from those numerical predictors, which of course reward long-standing inequities and advantages in educational opportunity that has always been influenced by race throughout this country's history.
All right, another question.
Thanks. Hi, Kevin Harrington. I'm 3L. Disclose the bias. I'm one of Professor Reyes' former students. This is a question for you, Professor Blackman. Professor Reyes has mentioned that originalism is not actually value neutral. It's a set of tools among others that can be used to promote a specific ideology. Hopefully I haven't rephrased that incorrectly. How do you respond? Is originalism value neutral, or is it a set of tools that's used to
Thank you. And you paid attention as a student very well. So let me tell you a couple cases about Justice Scalia. Now, Justice Scalia was a conservative, a law and order guy. He didn't like criminals very much, but he had a very specific view on the Confrontation Clause. Have you studied that in any of your classes? Right, the right to confront your accuser. And for the longest time, the Supreme Court had a test, was Ohio v. Roberts, which said you can admit out-of-court statements so long as they're reasonable. This very wishy-washy test. And Scalia said no. There's a very strong history going back to the trial of Sir Walter Raleigh that you had to confront your accuser face to face. And Justice Scalia advocated the position for years, and finally he got a majority in a case called Crawford v. Washington. And he expanded on that in a case called Melendez-Diaz versus Massachusetts, a case from not even a few blocks away, where you had a lab tech somewhere in Boston who was basically fudging, CSI, crime scene evidence. Now, he uses evidence to show that there are at least some cases where an otherwise law and order conservative rules in favor of criminals. Justice Gorsuch is perhaps the strongest originalist in the court today after Thomas, but he's also one of the strongest on defendant rights. And there are many cases where Gorsuch votes in favor of criminal defendants they might not otherwise. I absolutely do believe that originalism does constrain. And let me just give you the opposite, right? If originalism has no constraint, imagine what a conservative Warren court would do. Not only is there no right to abortion, abortion laws are unconstitutional. That the 14th Amendment guarantees the right to life. Imagine what a conservative Warren court would do if there was no constraint by originalism. It'd be a very different society. So I do think originalism constrains. I do think it does check what they do, perhaps not as much otherwise. I think all judging has some values embedded in them, but I think it's a lot better than the alternative, where 5 justices can say, what do we think is the best rule? Right? What do we think is the best society? What do you think achieves justice if we understand it? I would much prefer to have 5 Justice Thomases or 5 Justice Scalias and 5 Justice Brennans any day.
And just as a counterpoint, I dare say that most Black, brown, indigenous Americans would choose the opposite.
Hi, Brendan Kelly, Turiel here. Thanks to both of you for being here tonight and having the discussions. So I want to go back to the Harvard and UNC cases, and obviously correct me if I'm wrong, but I think in the Baki case, 4 of the justices, the majority, wanted to read the 14th Amendment Equal Protection Clause as addressing past racial discrimination that had happened to remedy the systemic injustice that had happened. But then Justice Powell, who I believe wrote the opinion, did it in favor of the value of diversity.
Correct, yeah.
And so I guess my question is kind of 2 parts. One, do either of you think there's a constitutional backing for diversity?
do this
If
one?
not, is there anything that like colleges can do? So say as a society, we agree that diversity of all kinds is really good in higher education. Is there a constitutional argument for that? And if there's not, are there any things that like the government could do? If the court's saying vote on it, how could we possibly vote on something?
Do you want to take this one?
I'm happy to, or you can go first.
You go first, yeah.
Yeah, so if I'm understanding the question correctly, I absolutely do think that diversity is consistent with the Equal Protection Clause, right? So the way the court has read the clause in the affirmative action cases and some of the disparate impact cases seems to suggest that any attention to race is really the constitutional evil that's meant to be addressed. I think that's utterly absurd, right? The Equal Protection Clause isn't about prohibiting recognition of difference, right? It's about prohibiting white supremacy. That's why we have the Equal Protection Clause. It's not because people recognize that there are phenotypical differences in the way people look. It's because there was a racialized hierarchy with white people on the top and enslaved people at the bottom, right? Treated not as people, but as property. That's what the 14th Amendment is all about. So to say, yes, we are going to take account of disparities in educational opportunity. Yes, we are going to take account of the realities of residential segregation that have their genesis in centuries, right, of legally mandated restrictive zoning covenants, et cetera, et cetera. So taking account of that, completely consistent with the Equal Protection Clause. But maybe I'm not quite getting at the question.
No, that is, but then I'd want to push it further. Like, I think then we can talk maybe explicitly about like Black Americans in those cases, but I'm talking about other diversity too, socioeconomic or religious or sexual identity.
Yeah,
those
let me jump in. So, you all read the Bakke opinion. Now, you probably read Justice Powell's opinion. Did you read Justice Thurgood Marshall's opinion? Did you assign that one in your class?
In brief, yes, we get all of them in brief.
Which, so I have a common law casebook, and when I first came to it, we did not include we did not include Justice Marshall's dissent, or partial dissent, so I added it. Read the Marshall opinion, and what he writes is, all this stuff about diversity is nice, but the reason why we have affirmative action is indeed to make up for centuries of oppression of Black Americans. He was very candid about this. And by reducing affirmative action to this idea of diversity, we're trivializing what we're talking about, right? Because almost views, to use the phrase tools, it used minority students as tools, as ways to just provide some perspective in the classroom for the benefit of others. And that's almost a diminishing perspective. Had the Supreme Court latched onto this century of oppression approach to affirmative action, it'd be on a much stronger footing. But the idea of just using minority students as a way to just enlighten others, to bring a perspective to classroom debate, I think trivializes what we're talking about here. So this sort of fixation on diversity stems from Justice Powell's middle-of-the-road approach. Now, one of the reasons why this a century of oppression argument may not have been favored, and Renee will disagree, is that if you say that there's some history of oppression and we need racial preferences to bring people up to speed, eventually there's a stopping point. Maybe not. Maybe there's never a stopping point, but people say, remember, there's a stopping point, we're there. And the other issue is that not all groups have been subject to the same amount of oppression. This was Brandon's question. And perhaps some minorities have been subject to more or less. And then a university would then have to calibrate their preferences based on the level of oppressiveness, I suppose, that a particular group has experienced. And they need to say, well, what if a person's of mixed race? What if a person has this socioeconomic status with this race? I think it's very complicated. So the current status quo, would you say diversity sort of elides or puts a cover over what's a lot of stuff that's really going on under the hood. And I don't know how much the court will even confront this, but I think a lot of the universities have rationales. They're not always, that are somewhat just sort of garnished by the phrase diversity. That's how I see it.
Yeah, and I think part of that is a product of the court's own approach to race-conscious affirmative action, right? It's like Derek Bell's interest convergence theory. Well, we're not going to have diversity for people of color unless it also benefits the white majority. Yes, if it benefits white people, yeah, sure, diversity is great because look, all these white people now learn how to work with people of color, and that's advantageous when they go into the workplace and the government, et cetera, et cetera. So to interpret the Equal Protection Clause in such a way as to primarily be about the white majority and serving their interests, as opposed to people of color, I think is a perversion of history, a perversion of the constitutional language, the emancipatory, abolitionist, equalizing potential of the Reconstruction era amendments. And I think the current rhetoric that universities employ is a reflection of that perversion.
Other questions?
We can get a couple
And by the way, before he goes, I just want to say thank you, Professor Reyes. It's very rare today to have two people who disagree as much as he and I do have a civil debate. We're not throwing food at each other. So I just want to say thank you. And no, sincerely, I go around this country speaking at law schools, and it's rare to get an actual meaningful debate. So I want to say thank you sincerely for your time.
Pleasure. Yes, thank you for being here.
Thank you.
I'm not leaving yet. Two more
Okay,
questions.
okay,
Either
two
one or
more
two
questions. Two more questions. But I wanted to get that out there before we started walking out.
Uh,
And what's your name and what year are you, please?
My name's Austin. I'm a 3L. I was at your last talk last year.
I thought you looked familiar. Yeah.
I really enjoyed it. Yeah.
Thank you.
So I guess my question is, in such like a polarizing time as we live in now, before the Roe overturn came out, you saw a leak of the opinion come out, and I thought, whether I agree with overturning or not, I think that's extremely damaging to the process of our Supreme Court and extremely dangerous, because now you have people showing up at Supreme Court, justice houses with guns and so on and so forth. And but then you had people on the left who said, yeah, it should have been leaked, and then you have people on the right saying, no, it shouldn't have been leaked. And I just would love to get both y'all's takes on that.
Do you want to go first in the league?
Go right ahead.
So look, we don't know who leaked the opinion. We don't know why they leaked it. I have a couple theories, none of which I can back up. I'll give you the theories anyway. As we're in law school, we don't need evidence here, right? Value neutral, right? So one theory is it was a leak from the conservatives. That is, maybe Kavanaugh was on the fence. He was getting a little wobbly in the knees, and by putting this out there, they lock in the votes, right? Because he can't go back. If the public knew he was there at the beginning, he'd have to stay with it, right? That's theory number one. Theory number two is a liberal leak. That is, one of the more liberal justices or their clerks leaked the opinion to try to create a public outroar. And the thinking was, oh my God, if only Kavanaugh could see how angry people are, he'll change his mind and vote with the left, and then maybe vote with the Chief Justice or something else. And then there's option three. This is what I call the burn it down option, where maybe a clerk said, pardon my French, fuck this, right? This institution's failed. I don't care anymore. And I want to embarrass and humiliate and shine a negative light on the court as much as I can. And I'm going to just give this opinion to the press, and we'll let the chips fall they may. Now, I don't know which theory it is. There's also a fourth theory. Maybe it was a foreign hack. I don't want to rule this out because we can't rule anything out. But maybe Justice Breyer was reading opinion on his iPad or something. We don't know, right? We have no idea. But what's clear though is that this leak destroyed trust on the court in ways that were not anticipated. And if it was even conceivable that the votes could have moved around, the leak stopped that cold. Right? Because after the leak, no one trusted each other. People didn't talk to each other. The justices were sort of cloistered in their chambers. And then, as you mentioned, we had an assassination attempt. Right? So if anyone taking crim law this year, it's almost like a fact pattern. Guy Googles online on assassination. He purchased a gun. He looks up Justice Kavanaugh's address. He puts a gun in a bag, flies cross country, goes up to the guy's house. He has a little padding in his backpack so he could walk around without tiptoeing on his shoes. Right? He pads his shoes. And then he sees the Secret Service detail, the marshal detail, and he says, uh-oh, never mind. He then calls the cops and says, I'm turning myself in. Is that enough for attempted murder? Is there a substantial step? This is not, this is actually, I think, putting aside everything else, it's actually a very hard criminal law question. I'm not a scholar in criminal law. But still, you have to think, Kavanaugh said, wow, this guy wanted to murder me because of the vote I was going to cast in Dobbs. That's serious. It's amazing. I'm grateful no one got hurt, but that was a very serious move. So there were so many things that happened this past year between the leak, the assassination attempt. We're still under COVID with the lockdown. There were so many things that happened. And the justices probably just weren't talking to each other. And maybe that could have softened the blow of the opinion that Dobbs visually came out. I think it's entirely plausible.
Yeah, I don't know anything at all about the genesis of the leak. I understand the court is approaching the end of its internal investigation, so maybe there'll be some resolution there. I really don't know. But, quite frankly, the leak itself is far from being the worst outcome that happened, last term. I think the substance of the opinion far more concerning, institutionally, substantively, constitutionally, than the kind of internal question about whether clerks or anybody else at the court is leaking information to the press. So that's not to dismiss the importance or the collateral effect, but again, I don't think it's anywhere close to being the most important element of the Dobbs story.
Do you think it's like harmful to the process and kind of sets a harmful precedent though for the court to start leaking opinions like that? If you disagree with it?
Honestly, I don't have a strong opinion about, should the court be circulating draft opinions? I mean, is that necessarily a bad thing, right? You have draft legislation, bills are marked up, they're debated openly and publicly in Congress. If this is effectively just another lawmaking branch, which in many ways it is, why should it be shrouded in so much more secrecy than the other branches of government are? I'm not saying I'm necessarily endorsing that to the hilt, but it's at least worth considering, right? Is the absence of transparency that currently characterizes the Supreme Court, is that necessarily a good thing? I'm not sure.
What other questions we have?
I can do just one more.
One more question.
So circling
And
back
what's your name and year, please?
Curiel, I'm a 3L. So circling back to sort of the beginning of the conversation, when we were discussing, or you rather were discussing, cases coming up in the remainder of this term, in the Dobbs case, we saw them deliberately take aim at Bergefell, sodomy laws, contraceptive laws cases. In this upcoming term, and maybe the next one, are there cases where you feel like these things that the court already seems to have in its sights are going to be in jeopardy? I think a lot of people who disagree with Dobbs are very concerned about this and how far they're going to go back down this line of cases. I think some people have even said, what about Loving? How far back are we going to take this? So where do you think this is going to end up going, and what
Sure.
rationales will make it used for that?
Sure. So when you say they, it was more of a one. It was Justice Thomas, right? So Justice Thomas wrote a concurrence in Dobbs that no one else joined. And Thomas suggested that if we were taking substantive due process seriously, we should overrule other precedents, including a Bergefell, which was gay marriage, a Lawrence involved homosexual relations, and Griswold, which involves birth control. So I have a couple of responses to that. So first off, no one else joined Thomas, right? I don't think any other justices have the appetite to go quite that far back. But even if they did, I think public opinion would render that not very likely. Gay marriage is now a 70 to 80% issue in popularity. Birth control is probably close to 100% or something close to it. Even when Griswold was decided in the 1960s, Connecticut was in the process of repealing their birth control law. So I think what would have to happen is you have to have a legislature try to ban birth control. Okay, good luck with that. I don't see that statute being enacted. Or perhaps a clerk could deny a license to a gay couple as a challenge to a Bergefell. If that happens, they'd lose in court, no qualified immunity, they pay attorney's fees, and I think that's unlikely, and the Supreme Court denies cert. What made Dobbs unique is that you had a legislature knowingly adopt a law for the express purpose of challenging Roe, because it was such a contentious statute that had been controversial for decades. Right? Involving Loving, people like bringing this up. Loving was primarily about equal protection. Right? There were two parts of the opinion. There was equal protection and then due process. I think even Justice Thomas would agree, and he said so much in a Bergefell, that Loving can be understood as an equal protection case, that a classification on the basis of race is unconstitutional. The substantive due process part of Loving is a little bit more tied to Meyer v. Nebraska and Pierce Society of Sisters, but I think you could have Loving even without due process. That's my perspective.
Yeah, and I would say that I am less sanguine, less optimistic about the stability of those other cases. Yes, Justice Thomas wrote only for himself, but he's absolutely right that the logic of the opinion leads to that possibility. Now, practically speaking, will it happen? Maybe not right away, but incrementally over time, I think it's entirely possible that we could see an erosion of some of those other cases, particularly LGBTQ plus equality. I think that is on very fragile ground, particularly given the ascendancy of religious liberty arguments, which Professor Blackman alluded to at the beginning of his presentation. Now, Justice Blackman points out that...
Justice Blackman, Lord help you. Lord. You want me nowhere near a bench, nowhere near a road. Lord help you all. Let me stay in the academy.
And I expect to be confirmed, on the first of never myself. So
I'll see you there.
on the bench, right?
Yeah.
But popularity, right? Says there's popular support for same-sex marriage and contraception. But it's Professor Blackman who told us that Justice Alito says we don't care how popular or unpopular a decision is, right? Majorities support abortion rights. Majority support affirmative action. Majority support greater room for gun control than the Supreme Court is allowing. So I think there's a tension there, right? Saying that because it's popular, it's safe. When again, Justice Alito says, who cares if it's popular? So I think there are definitely reasons to be concerned and vigilant going forward.
We good?
Thank you all for coming, and
Thank you so
thank
much.
you,
My pleasure.
Professor
Nice talking with
Blackman.
you.
I hope you do this again.
Yes, yes.